And so here, it's very much not unusual that the Georgia Court of Appeals decided to issue a stay because it was, in fact, Judge McAfee who was pushing the button a little bit by saying that he could move forward with some of these substantive pretrial motions. And so, if anything, it is just pretty much par for the course, but even a little bit earlier and moving faster than they usually would.
It's the Lawfare podcast, Trump's Trials and Tribulations. I'm Benjamin Wittes with Anna Bauer, Roger Parloff, and Alan Feuer of the New York Times.
And then for you masochists out there, I'll just mention that on the day that they granted cert, if they had instead denied cert, jury selection could have started a week ago Monday.
Hey, everybody. Welcome to this week's Trump's Trials and Tribulations. We are back on our regular schedule, you know, the whole Thursday afternoon at 4 o'clock Eastern time thing, rather than this every day for half an hour at unspecified time thing. I am back in the Hammock studio in Washington, D.C. Roger is joining us from the Scott studio. Anna Bauer, what room in your palatial mansion are you joining us from today?
This is the New York trial is over room of my palatial mansion.
Yes, which appears magically whenever a trial in New York ends, but otherwise does not exist. And joining us for the first time, special guest Alan Feuer of the New York Times, one of the few reporters who has been to just about every courthouse that these cases involve. Anna and Roger have. Welcome to Trump's Trials and Tribulations, Alan. Thank you for joining us today.
Thanks for having me.
So we're going to do New York last today. We're going to start in Fulton County. The Georgia Court of Appeals has put the nail in the coffin of anybody's hopes of having this trial before the election. Is it fair to say that the Georgia case is now off the table entirely for pre-election purposes, or is there some glimmer of hope that people who want to rely on criminal trials to shape the election should hang on to here?
Well, Ben, I mean, it's no more likely to happen than it was before. For listeners of Trump Trials and Tribulations, you will know that we've been saying since the Court of Appeals decided to take up the case that it was very unlikely that this case, or almost even impossible, that this case was going to go forward until 2025. But that was confirmed yesterday when the Georgia Court of Appeals entered a stay, which pauses all of the proceedings in the trial court in Fulton County for at least 9 of the remaining defendants in the case. And most of those defendants are people who are the so-called big fish in the prosecution. And
before you go on, walk us through the distinction between the 9 and the other 6. Why are some people stayed and some people not stayed?
Right. So keep in mind, all of this relates to the motion to disqualify Fani Willis. It relates to the argument that was made back in January and February when we had those evidentiary hearings about the relationship between Nathan Wade and Fani Willis, and the question of whether or not there was some impropriety about either the relationship itself and the financial benefits potentially accrued by Fani Willis or Nathan Wade through that relationship. But then as things went on, there were also allegations that were made about what's called in Georgia forensic misconduct. That means extrajudicial statements. Those statements relate to statements that Fani Willis made in a speech at a church in Atlanta that the defendants allege were about them. They said that it prejudiced their rights in the case. And so there were kind of those two issues. And then also on top of that, after we had the evidentiary hearings, there were questions that were raised about how candid Fani Willis and Nathan Wade had actually actually been with the tribunal because there was this back and forth about the defendants alleging the relationship started earlier than what Fani Willis and Nathan Wade testified to during the evidentiary hearing. So that's the background. Judge McAfee then issued an order saying you can choose between Nathan Wade or the case. Fani Willis chose the case. Nathan Wade resigned. And then the defendants appealed to the Georgia Court of Appeals, which is the intermediate court of appeals in Georgia. We know from New York that sometimes courts of appeals have very weird and different names. In New York, the Court of Appeals is the highest court. But in Georgia, the Court of Appeals is the kind of middle level court.
But that's the naming convention you would expect,
right?
It
is the one you expect. But now after
New York is kind of the outlier here.
I'm very careful. Like, I think the reason you said Supreme Court in the beginning, Ben, is because you had New York Supreme Court on your mind. But anyway.
Also, DC Court of Appeals is the highest court in D.C., not to be confused with the D.C. Circuit Court of Appeals, which is the mid-level court.
The point is just that this is now going to the Court of Appeals, but keep in mind that there were a number of differently situated defendants here. So some of them did not actually have the same pretrial deadlines as others did when this initial motion to disqualify Fani Willis was made by Mike Roman's counsel, Ashley Merchant. And so at the time, you had people like Sean Still or Travion Cootie, who had extended deadlines for, in Sean Still's case, he was a member of the General Assembly, and so his deadlines were extended until he's done being a state representative in the General Assembly in Georgia. And then Travion Cootie had different deadlines because she didn't have counsel. She had a change of counsel. And then you also had some defendants who just chose not to join the motion. So that's people like John Eastman, that's people like Misty Hampton. And so those people who didn't join the motion or had different deadlines are not a part of this appeal. And when we had the order from the Georgia Court of Appeals yesterday staying the proceedings, it listed all of the case names that were stayed, and it was just the people who had actually joined the motion and then therefore appealed. However, keep in mind, the Fulton County District Attorney's Office has also cross-appealed because they're allowed to do so under Georgia appellate court rules. Whenever there is an interlocutory appeal, then the opposing party can kind of just add on these cross-appeals. That has not been docketed yet. It is the appeal of the Judge McAfee's dismissal of the solicitation of oath of office counts. That includes people like Trump. That includes people like Ray Smith, people who did not join the disqualification motion, but who are now subject to this cross appeal. And whenever that case is docketed, I think it's very likely that those folks, Eastman and Smith, will be kind of pulled into the stay of the proceedings as well. So I know that that's a little bit complicated, and I can explain it more if I didn't do as good of a job clearly explaining it, because again, it involves a lot of weird appellate procedure kind of things. But basically, there are 9 defendants whose cases are stayed. It involves people like Trump, like Meadows, like Giuliani, all the big fish. And then there are 2 others, Ray Smith and John Eastman, who might be also stayed as we go forward.
All right. I know what half of our audience is asking right now, so I'm going to pose this question to you, which is, should we look at the Georgia Court of Appeals stay here as analogous to the Supreme Court getting involved and moving at a pace less quick than a lot of people want, that has the effect of slowing down the January 6th case? This is the Georgia Court of Appeals kind of slow walking the Georgia case. Or should we look at it as kind of the Georgia Court of Appeals doing the Georgia Court of Appeals thing, regular order? There's an interlocutory appeal that the judge certified for it. It's their job to take a look at it. This is kind of what Boy Wonder told them to do. How do you see the stay in terms of I mean, we know what the effects is, but should we look at it as a political gesture to slow things down?
So I can answer this question. But Alan and Roger, if you want to jump in, please do. So no, this is pretty much standard. To quote Emil Bovee from the New York trial, this is standard operating procedure in Georgia appellate practice. So actually what was unusual, Ben, is what Judge McAfee did. Remember, after Judge McAfee granted permission to these defendants to actually try to appeal to the Georgia Court of Appeals. And then the Georgia Court of Appeals eventually did take it up. But when they did so, Judge McAfee entered an order granting this certificate of immediate review that they needed to go to the Court of Appeals in the first place. And he retained some jurisdiction for himself. He said, I'm going to keep making some movement and moving forward on these pretrial motions. And that was actually what was unusual, because typically whenever you have an interlocutory or before trial appeal in Georgia appellate practice, it just pauses all the proceedings automatically. And trial court judges typically just do so as a matter of course. And so here it's very much not unusual that the Georgia Court of Appeals decided to issue a stay, because it was in fact Judge McAfee who was pushing the button a little bit by saying that he could move forward with some of these substantive pretrial motions. So this was very much not unexpected. I also will say, too, that I've heard some people expressing concern about how far out the Georgia Court of Appeals set oral argument. We know from the docketing of the case that they have tentatively set oral argument for October 4th. That is actually almost a little bit earlier than what you would expect in normal practice in Georgia. And so if anything, it is just pretty much par for the course, but even a little bit earlier and moving faster than they usually would. This is a very busy Court of Appeals. They don't tend to move super fast, and this appeal was not expedited. So it's all of this is just very normal. And even though these are judges who are elected courts of appeal judges, I've said before that Georgia is not
a political appeals system.
Right. I mean, look, they're nonpartisan judge races. I will say the Georgia Court of Appeals is relatively conservative, but again, it doesn't have the kind of partisan influence that, for example, I've compared it to the Texas Court of Criminal Appeals, in the sense that it's not like that. It's very much, a very professionalized legal system within our appeals courts in Georgia. And so I really just don't think that what we're seeing here is a slow walking in the way that we see in the Southern District of Florida with Judge Cannon, where I do think that there's an element of
different picture, and we're going to come to that in a moment.
Just to round out the comparison to the January 6th Washington case, it seems like what happened in Georgia is more akin to the situation that Judge Chutkin confronted when her immunity decision was appealed by Trump's attorneys. She had really no discretion to avoid staying the case while that immunity issue went up on an interlocutory appeal. There was much more discretion in the D.C. Circuit and, of course, at the Supreme Court in how quickly those judges move. But the initial decision to freeze the January 6th case in place, it wasn't really a decision at all.
Right.
I think that's right, Alan. Exactly right. There was a little bit of wiggle room maybe in the case law. Like there was some dicta that Judge McAfee cited when he tried to hold on to some jurisdiction. But one thing, Ben, I know you want to move on to Florida. And so I will add here something I didn't mention earlier about the effect this has on individual defendants. That is kind of the big unknown here, because we do have this stay that affects 9 of the defendants. But at the same time, we saw today Misty Hampton, for example, who's one of the defendants who did not initially join the motion to disqualify and therefore is not part of the appeal. Her counsel filed a motion to stay with Judge McAfee, making the argument that even though the Court of Appeals, they argued it was kind of unclear that maybe the whole case is stayed, but regardless, even if it's not, they said as a matter of judicial economy, you should still stay Misty Hampton's case too. She's not severed out, and so she's a part of these other defendants' cases. And then they also said, if the Court of Appeals decides that Fani Willis should be disqualified, then that will apply to Misty Hampton as well and the entire prosecution, even though she did not initially join the motion to disqualify. And I think that's going to be a big issue here that I don't know the answer to. Some Georgia attorneys that I've talked to have said, well, yeah, on the one hand, of course, they would have waived the ability to join the motion in the first place because they had an opportunity, they didn't join.
But the judicial economy argument is pretty hard to argue with here. I mean, you're going to hold up the whole case for the 9 marquee defendants and move forward with the same case involving a bunch of the same motions that you'll then have to redo for 6 other defendants. It actually seems pretty silly to me. And the argument for, if you're going to stay it for Trump and Giuliani and Meadows, to stay it for the rest of them sounds actually pretty reasonable.
Well, and I think the opposite of that, though, is if you have any defendants who do, again, I think John Eastman's case will be stayed eventually because he's a part of the cross appeal. His charges, one of his counts was dismissed, and then now it's been wrapped up in this cross appeal, but it is not technically stayed yet. And John Eastman said in filings previously that he wanted to be tried before 2025. And he has said that he wanted to be tried separately from Trump. And Judge McAfee has indicated that he thinks that they would maybe need to do smaller trials with, groups of defendants as opposed to one big group like the district attorney's office wants to. So those are just some considerations to throw out there that might go in the opposite direction. And I also don't know, of course, what the district attorney's office wants to do. They have said that they want to try everyone together. And if that is their goal still, then I don't know why they would want to go ahead and move forward with these other smaller fry people that they probably would much prefer to see plead out. So I don't think that we're going to see any trials of these people whose cases aren't stayed, but it is still a possibility at this time.
I'm going to say something that's going to make people mad at me, but I'm going to say it anyway. The moral here is a moral to the prosecutors, not to the court. If you want to move your case quickly, economize on the number of defendants. You really didn't need to indict 19. Don't have an affair with your special prosecutor, and don't exchange wads of cash for your travel reimbursement, because that just gives rise to litigatable issues. All right, let's go 500 miles south to Fort Pierce, where Judge Eileen Cannon has been busy not deciding things, but queuing up her next set of hearings. Alan, get us started. What is on her plate? Or let's start with the first big thing on her plate, which is that the Justice Department, the special counsel's office, has in fact refiled its motion to change Trump's terms of pretrial release. And so where does that stand? This grows out of a desire for some kind of gag order in light of his calling out the troops against the FBI and suggesting that the FBI was trying to kill him. Where do we stand with that now?
Well, right now, that issue is about to get briefed. So Jack Smith made his motion asking Judge Cannon essentially to stop Trump from saying anything publicly that might endanger the FBI agents working on the documents case any more than he already has. And the mechanism that Smith wants to use is not technically a gag order of the sort that Trump has faced in both Manhattan and Washington. Rather, he wants to make this limit on Trump's ability to threaten and endanger the FBI contingent to Trump's conditions of release, so that if Trump goes out and says, things that could, lead to the intimidation or harassment of agents, in theory, Judge Cannon could revoke his bail and take him back into pretrial custody. So next week on Friday, we'll hear from Trump's lawyers on the merits of that argument, the substance of it. They've already called this an unprecedented, unconstitutional censorship application, right? And then, we'll get a reply from the government, and then we will get a hearing on this issue. Presumably, it will sound something like the hearing that took place in front of Judge Chutkan way back when Judge Chutkan was considering a gag order, and it will obviously
somehow I don't think it's going to sound a lot. Like that,
I guess it will tread similar ground. How about that? Obviously, the issues at play here are fairly obvious, right? On the one hand, the government wants to limit Trump's speech even as he's running for office in order so that he does not put people in danger. Pretty basic. And then, Trump's lawyers will surely claim that this is an unconstitutional infringement of his First Amendment rights, enhanced by the fact that he is, as they like to say, the leading candidate for presidency. So that, I believe, is taking place on the 24th or 25th of June. So,
Roger, my sense of this is that given the magnitude of the claimed threat, that she has adopted a pretty leisurely briefing schedule here. That, the government comes in and says Trump is making outrageously false and reckless allegations that the proximate result of which could be attacks on FBI agents. And she first says, well, you didn't consult properly before filing this brief, get out of my court. Then it takes them a week to refile it because they have to go through and document all of the consultations that they're having. And then, she sets a briefing schedule that kind of treats it like, they were alleging that there was a kind of risk of jaywalking here. How do you line this up against Judge Cannon's other dilatory practices?
Well, it shows no urgency whatsoever toward the claim, and the usual solicitousness of local rules, technicalities that assist the defendant. But at the same time, this was not brought as an emergency motion. And so there's a little bit of a built-in problem, I think, for them, given that, it's a very big ask. And in fact, one thing that I guess we won't know until argument, maybe, or maybe the reply, is why they chose a different mechanism. We already have a gag order in place that's been approved by the DC Circuit. We haven't yet had one that takes the form of a modification of the terms of release. And I don't know why this is a novel thing. And when they refiled, they only had one more exhibit than they had originally. And also some of the most egregious instances of, statements that are being made are, of course, his surrogates and not him. So, she's always been a stickler for when, this was the same issue when she wanted to reveal all of the FBI agents' names. Remember, she ordered that. And then on reconsideration, she was talked down from the ledge. But she kept saying, well, what's your showing of particularized need? I mean, I know some guy attacked the Cincinnati headquarters of the FBI with a gun and shot at people, and he was killed in a shootout. But what's your particularized need? And that's a pretty steep standard that she's articulating. She wants something more than that. They haven't
hit this FBI field office.
Yeah, exactly. And that's sort of the defense that Trump is saying, well, you shielded their names. People can't go after these FBI agents. That's sort of the defense. But since they didn't ask for, they themselves were not more urgent. It wasn't an emergency motion. I wonder if that isn't going to sort of hinder the strength of this argument.
So, Alan, one of my suspicions about this motion is that the attraction of it from the government's point of view is that it's appealable on an interlocutory basis and it's not a SEPA order. So that, you know, if your secret goal as Jack Smith is to get something in front of the 11th Circuit that says, save us from this crazy person, having a motion that is, he's endangering the FBI agents and she's fighting with us about whether we've consulted enough before we've filed the brief. And then she sets up this very leisurely briefing schedule. Take a look at this case and think about whether she's right, and also whether, you could reassign it to somebody who's a little bit less obviously in the president's corner. Do you think that's part of what's going on here, or is this just about the specific matter that's in front of her?
I mean, if indeed Jack Smith is filing this motion, at least in part, to create an appealable issue so as to bring it up to the circuit to achieve the larger goal of removing Eileen Cannon from this case, that seems like a very roundabout way to get something accomplished, and it is probably going to end up failing because there is very little chance that sort of recusal or removal by others is going to sort of take place over this issue by itself. Like, if you're just creating an issue.
But maybe creating a record.
I mean, look, maybe you're creating a record, sure. And that, I believe, is happening. I think that the special counsel's office is absolutely, sort of creating, for the lack of a better word, a dossier of complaints. I mean, look, I actually think that this motion is filed, even though it may be sort of technically insufficient in the ways that Roger was mentioning, out of a good faith belief that, like the Justice Department has to protect agents, who work for the FBI. That's why you saw Merrick Garland, who says almost nothing about these cases, address the issue head on. I think that this is like a protect your people kind of thing. And if it has the, collateral effect of being yet another way to sort of build a record about Judge Cannon, sure. But I would be quite shocked if it was designed to do that. I mean, to Roger's point, though, the fact that the government can't point to any particular FBI agents who have suffered threats or intimidation because of Trump's, blatant and dangerous lies about the FBI's use of force policy, I think it does create a bit of a problem. Let's remember when Smith went to Judge Chutkan in the January 6th case, he could point to several actual witnesses or, potential witnesses in the case and say, hey, Trump said this about Mike Pence. Trump said this about Bill Barr. Trump said this about, Mark Milley, et cetera, et cetera, et cetera. So, it's in front of this judge in particular, I think you need a very strong case. And while, in the sort of theoretical sense, it's worthy of attempting, I don't know how far they're going to get.
Anna, did you want to get in?
Not much to add there, other than just to say, I think at this point it is probably sunk in within the special counsel's office that this case is absolutely not going to trial before the election. And it's kind of like, if it is whether it's a morale boosting kind of thing in the way and a protect your people type of thing, the way that Alan described it, it's kind of like, why not take the steps now to do what you can, because it's clear that Judge Cannon is not moving forward with this case before the election as they wanted. And so I think that, that's just one thing that is maybe going on here, is that, it's kind of a why not? It's not going to slow things down anyway, because things are already moving at a snail's pace.
Right. All right, so let's go on to the issue that Judge Cannon seems very keen to have arguments about, including from a diverse array of non-parties. Roger, get us started on this. We're going to have a hearing on Trump's motion to dismiss on a variety of grounds, and we're going to hear from some amici on this. What's going on here?
Yeah, on June 21st, this is a two-part motion. It's a motion to dismiss based on the theory that the special counsel was unconstitutionally appointed. And then a second half of it is that it's being unconstitutionally funded. The second half is much, much weaker. So she scheduled June 21st, a Friday, for the first half, and the morning of Monday, the 24th, after that for the second half. And then 3 amici have asked and been permitted to argue. She's allotted them an extraordinary 30 minutes each, so 90 minutes extra. It's a very unusual thing in a district court level case and in a criminal case. I can think of almost nothing similar I've seen, but it's also an issue. It's a recurrent issue that conservative scholars always have had problems with for decades, and so there are a number of cases out there that seem to approve of what Merrick Garland did here in appointing Jack Smith. The problem is that some of them are not recent. None of them are 11th Circuit. And one is a 1974 case, United States versus Nixon, but the precedent there is arguably dicta, or that's how they're presenting it. It was an issue that wasn't briefed there. There's another case in 1988 that's actually 7-1, but the one was Justice Scalia, and so the sainted Justice Scalia. And the other thing that I think is making this very significant for Cannon, who I think to begin with would really like to be an appellate judge, as would many district judges, but I think, we've seen she would really like to be promoted. And the amici here include people like Ed Meese, a professor named Steve Calabrese, who I see is the co-founder of the Federalist Society. And these people basically invented originalism in the mid-'80s. They certainly were the big proselytizers and then there's a former judge and former Attorney General Michael Mukasey. So these are people that she admires, she cares about, and she models her jurisprudence on theirs. And I'm sure this doesn't enter into it, but these happen to be people who could advance her career too, as could Trump. And so she needs to take it very seriously. If she's going to deny it, it's going to be an opinion that says, you make a terrific point. You're absolutely right. I agree with you on the textualism, but my hands are tied because of these, Supreme Court. That's how it's going to read. On the other hand, she might say, you know what? I can cling to some new Supreme Court decisions and say they imply those other ones are no longer operational. Maybe I'll go with this one. And we know there are justices on the Supreme Court that would go her way. I mean, Justice Clarence Thomas, in the middle of the immunity argument, out of nowhere said, has anyone challenged the special counsel in this case? So I don't know what she'll do with this.
This is an issue that I have lived with really almost my entire adult professional life, between the independent counsel challenges and then the subsequent creation of this regime. And I got to say, I agree with everything you just said about the way this case is presenting to her, but this is not a hard issue. And under whether you read Morrison v. Olson the way the 7-justice majority did, or the way Justice Scalia did in dissent in the famous Morrison dissent. This appointment mechanism is unambiguously constitutional. Jack Smith is appointed by the Attorney General. He is fireable by the Attorney General. He is not pursuant, he's appointed pursuant to regs that are promulgated by the Attorney General and that can be revoked by the Attorney General. He is clearly not, he has a limited jurisdictional mandate. And so my question, Alan, is what is the argument that this is defective? Like, trace for me what they are saying to her that renders this appointment mechanism, which, by the way, is the same one that was used for Robert Hur, for Bob Mueller, for what's the defect?
Well, look, the argument is simply that Jack Smith, it was not, confirmed by the Senate, and that therefore he was unconstitutionally appointed. And it has to do with what is the definition of an inferior officer, right? And the idea that the government will push back on is that, the appointments clause of the Constitution gives department heads, and in this case, the relevant department head is the Attorney General, the authority to appoint subordinates, and that Jack Smith, under the special counsel law, is effectively an inferior officer to the Attorney General. But I think that we're losing sight of a larger dynamic here that has kind of guided and described Judge Cannon's approach to all of these legal issues, which is that she simply seems averse to ruling on the merits of written argument, right? Like, this case could be briefed and then decided on the papers extremely easily. And it's not clear to me why two hearings are required, but for some desire on her part to give the fullest airing possible to a defendant of obvious import, to, slow, and which, regardless of her motive, has the collateral effect of slowing this case down to a crawl.
And Alan, do you like, Roger has taken this argument one step forward and further, and I'm interested in whether you agree with him, that she is temperamentally or just finds it very difficult to reject arguments from the defense in this case, and that she will, when she's forced to, she will write an entire opinion agreeing with them and then sort of reject it right at the end. But that it's not just that she resists written arguments, it's that she finds it really difficult to side with the government. How do you evaluate that?
Specifically, Trump. She has no trouble ruling against Nauta or De Oliveira. It's Trump. But go ahead.
No, I agree that there are certain parts, in her rulings where she will do it exactly as Roger described. She will ultimately make a decision in favor of the special counsel and do one of two things: either chide him, for the way the argument was structured or some other, infirmity in the argument process, or she will say, wow, Trump lawyers, you guys did a great job. Unfortunately, there's not much I can do here. So, yeah, I'm thinking it specifically of, like her motion that, so when she initially planned to release the names of witnesses in the underlying exhibits of all of these motions to dismiss, and wanted, was going to let a lot of like sensitive grand jury material, et cetera, go into the public record unredacted, Jack Smith kind of, said, whoa, this isn't done. He filed a motion to ask her to reconsider her decision. She ultimately sided with the government, but spent, like 3 or 4 paragraphs of her favorable ruling to the government, telling them how they had screwed up procedurally along the way. And that is akin to things she has done where she will grant a serious in-court audience to kind of quasi-frivolous defense motions, take up a lot of time fleshing them out and arguing both sides, and then ultimately make what seems like the right decision in denying them. And yet, why do we go through these exercises?
Okay, so two possible answers to that question. One is the conventional liberal wisdom, which is that she's trying to slow things down. She's also looking for ways to rule for him, so she'll entertain anything. Another way, a more generous way to look at it would be, hey, this is the biggest case she's ever going to sit on. You don't want something to go up post-conviction on the basis that you resolved something on the papers that, in a glib fashion. You want to be able to say, or you want who's ever defending the conviction to be able to say, hey, she gave this like kooky little issue full attention. She held a hearing on it. Is there anything to be said for this process? I mean, it does slow things down, but could you make an argument for it in the name of thoroughness?
Yeah, sure, you could if you wanted to. Look, at the end of the day, I think unless you're writing a biography of Eileen Cannon, the question of motive here is kind of irrelevant. I've done a lot of thinking about it. I've done quite a bit of reporting about it. I don't think that anyone can factually build a solid case either way. But at the end of the day, the impact it's had on the case is sort of the same, regardless of whatever the reasons she's doing it are. And frankly, if there comes a point when Jack Smith wants to go to the 11th Circuit in whatever capacity he has to ask them to move her off this case, I don't think there's going to be a lot of time spent on motive. I don't think they're going to try and psychologize the judge. What they're going to do is say, this decision she made was infirm for this reason, this decision was wrong for that reason. And they're just going to sort of show what she did as opposed to, try to divine why she did it.
I do have a gripe about this decision to give 3 days to argument on a somewhat meritless issue, which is that she set hearing dates on Friday and then Monday and Tuesday, if I am not mistaken, which means that all of the journalists covering the case must stay in Fort Pierce over the weekend.
Anna's long-term vendetta against the city of Fort Pierce will not go an episode without being voiced.
I want to. If we do an episode on that, please invite me back.
No, it comes up in every episode. It's not that we devote an episode to it. It's that Anna makes a point of injecting it into every episode. All right. Let's turn to the next issue, the hearing that Judge Cannon canceled. Speaking of hearings that are taking place, Alan, there's one that isn't taking place. Which one are we scratching off the agenda?
The one that got scratched was a highly unusual hearing to decide what is known as the scope of the prosecution team. And this is basically a mechanism for the defense to argue for an expansive discovery disclosure from the government. And so the defense has argued that the National Archives is part of the prosecution team, and that the intelligence community is part of the prosecution team, and the DOD and the Department of Energy and the top ranks of the Justice Department. And it seems that what the defense is truly after here is any kind of communication between the special counsel prosecutors and all of those other agencies that might help them bolster a claim that there was some sort of grand sort of conspiracy, call it a deep state conspiracy, call it what you will, where the Biden administration got together with all of these other sort of, Washington-based actors to improperly bring the case against Trump. And this seems to me like an effort to gather information in order to bolster what will ultimately be their selective and vindictive prosecution claims. And so there was going to be this weird hearing where effectively the defense was going to get to seek discovery from the government about the process by which the government gave them discovery. And the special counsel's office argued really vehemently against this, just saying this has never happened before and there's no authority to pry into our decision-making process on kind of how we allocate a discovery. You make a motion to compel, you make your arguments, and you either win or you lose. You don't then get to have a mini trial about whether our motion to compel discovery was sort of offered in good faith and accurately or not. And so she will ultimately put that back on the calendar at some point, but that was the one that got scrapped to do the ones that we were previously discussing.
And Roger, do you take the scrapping of that hearing to have to be some kind of substantive concession that there may be no basis to go forward with it? Or do you take it as just a scheduling thing and it'd be more fun this month to hear from Josh Blackman and other amici in the pure question of law? How do you read it?
Yeah, I don't think for a moment she's abandoned the plan to hold that hearing, which she also describes as a partial evidentiary hearing. So she would be taking evidence at this thing on some issues. No, I assume that this special counsel thing is increasing in importance in her vision, and she's also talking about possibly having an evidentiary component of that. I don't know even what she means. That would relate to the funding aspect of it, which is the challenge to the funding of the special counsel. And I just don't know what she even means in that part. And then she also substituted in another motion next week, the one about the motion for relief relating to the, quote, illegal raid, unquote, on Mar-a-Lago, and also the piercing of Trump's attorney-client privilege. This was sort of the crucial pretrial, here a decision that one of the crucial pretrial decisions that Beryl Howell made during the grand jury proceedings, and that's how we got to know about, Evan Corcoran's recorded notes, which were exceedingly damning, and portions of which are now described in the indictment, that Trump motioning to pick out the documents, pantomiming that he should pick out documents and implying that Corcoran should hide evidence and destroy it. So we're going to go over that. No, but like I say, I don't see it as conscious delay, because I think that she feels comfortable that she can, dismiss this case at trial or give instructions that will result in an acquittal. So I don't really think I think it's more this sort of OCD-ish personality and this desire to get A+++ on every motion, especially after that, catastrophe with the reversal on the special master she appointed by 3 conservative judges. She's ambitious and she wants everything everything is an audition for a higher job.
It would help her audition if she could write.
Yeah.
Alan, do you agree with that? No, Roger's point, not mine.
Which one? Just that.
Well, I mean, the general characterization of, again, without getting into her motives, what the ambience of her work has been.
Sure. Look, I think one of the most remarkable things about her courtroom demeanor and her sort of her style at hearings is that she has this weird habit of asking the same question over and over and over and over again. And it's hard to know if she's not quite understanding the answers she's getting back, if she's trying to sort of push at her interlocutor to, get a fuller understanding of their point, or whatever is going on. She just keeps asking the same question of both sides. And at the last hearing in late May, it ended up in a really dramatic sort of explosion where the one of the prosecutors, David Harbach, really just sort of lost his patience. And this is a guy, I mean, he's a career prosecutor. He was like a naval officer. He's just the most sort of even-keeled, presents in the most sort of, some AUSAs, some prosecutors have a sort of arrogance about them. That's not David Harbach. He's so grounded, but it finally he snapped basically under this sort of questioning process where Judge Cannon would not quite understand what he was saying. Are you saying this? No. Well, you're saying that. No. Well, you're saying this. And he was like, no, this is what I'm saying. And it happens over and over and over again. And it's the in-court version, I think, of what Roger is describing.
Yeah, and just to add too, for those who I wasn't at the last hearing, so I didn't witness that moment with David Harbaugh that Alan is describing, but I will say from going to a lot of the hearings down in Florida, just for some added context, usually it's either David Harbaugh or Jay Bratt who are doing the argument before Judge Cannon. And they kind of have a little bit of I like to think of it as a bit of a good cop, bad cop routine where Jay Bratt and Judge Cannon tend to have a little bit more of a relationship. Yeah, they butt heads. Thank you, Roger, who is making a motion that it has reminded me, yes, that's the correct term. They butt heads a little bit more than David Harbaugh, who is, you can tell there are times when Judge Cannon is just a little bit nicer to David Harbaugh. He can be very charming. And so it is very surprising to hear that he kind of lost it, because their dynamic throughout the hearings has been, at least relative to Jay Bratt, much better, much more kind of amicable. So that's just some context on that relationship that makes it even more interesting that David Harbaugh lost it at the last hearing.
All right, Roger, before we go to audience questions, it's time for a math update from the U.S. District Court for the District of Columbia. It is Thursday. Thursday is a decision day at the United States Supreme Court. If we had gotten a decision today in the immunity case, what would the math look like for a trial before the election?
Well, actually, I've done my math assuming that we didn't get it, and we didn't get it. And according to SCOTUS blog, we won't get another opinion date until June 13th. If they are right about that, the math is not very good for the prosecution. So if we get a ruling the 13th, the jury selection could start, and assuming that ruling gives a green light, and we don't need to further fact finding, which is a big assumption, the jury selection could start September 9th, Monday, September 9th, assuming 2 weeks voir dire and 6 weeks trial. The jury would start deliberating November 4th. So that is the day before Election Day. And then for you masochists out there, I'll just mention that on the day that they granted cert, if they had instead denied cert, jury selection could have started a week ago Monday.
All right. So I just want it on the record. Here is my prediction, which is that when the Supreme Court trims back the case under 1512C and demands further fact-finding in the immunity case, Jack Smith is going to respond by amending the indictment to drop a whole bunch of alleged facts and the 1512C. And so you will have, the math will improve or could improve because you trim the case to remove the stuff that the Supreme Court thinks requires more. We're going to go to audience questions. Richard Wattenbarger, the floor is yours.
Hello. I'd like to see if you can help me understand something. Under what circumstances would a convicted felon like Donald Trump, I really like saying it, I'm going to say that again, a convicted felon like Donald Trump, under what circumstances would he immediately begin serving a prison sentence upon sentencing? And can any convict delay serving their sentence while waiting for the appeals to go forward? How does this work? Because we know that often, someone's sentenced and hauled off.
Right. So, Anna, this is a different question under federal law than under New York law, since the relevant law here, assuming you're not speaking hypothetically, is New York law. There is actually a rather specific answer to this. Anna, do you want to?
My understanding from talking to attorneys who are New York attorneys is that Trump's whatever his sentence is, it could be basically suspended or stayed pending an appeal. And so I think that seems quite likely actually here.
It's substantially more liberal than the federal rule. The federal rule is if there is a substantial issue on appeal, the judge may stay it. The New York rule is more relaxed. It's if there's an active issue, if there's an appealable issue, there's no examination of how substantial that is, and it is routinely used in white-collar criminal offenses, convictions to where you don't have a threat of flight to issue an appeals bond. And so I would be shocked even if you don't get a stay from Justice Merchan, I would be very surprised if the First Department Appeals Court doesn't issue an appeals bond. So I think the circumstances, to answer your question very directly, the circumstances would be if Trump were to do something outrageous that would cause a reasonable judge or a reasonable group of judges to say, okay, the normal rule is X, but you've just gone one step too far. So think of if this question were sort of inflected by the contempt question. I think those would be the circumstances. Alan, do you have thoughts on this?
No, I agree with that entirely. And I think in the end, you're talking about Class E felonies here, first-time offender, all these things that, argue for leniency. And then you've got Trump's just unbridled remorselessness and his potential for, as you just said, for doing something really outrageous. And so at the end of the day, it seems like it's up to him. If he does something really crazy, there is a possibility that there might be sort of a quicker imposition of sentence. But I think all signs point to this. There's no way that Judge Merchan is going to seek to enforce a penalty before appeal. And then if Trump gets reelected, that sort of opens up another issue of what do you do? You're not going to imprison a sitting president. It's just not going to happen. So
I think the more likely scenario by which Trump ends up jailed is actually not the enforcement of a sentence. It's the serial violation of court orders leading to contempt. Because Justice Merchan very clearly said the last time, look, these fines clearly aren't doing it, so I'm putting you on notice. So you could imagine that the next time he feels like his hands are sort of tied. But I think that's actually more likely, just having watched him, than that you get a sentence that actually comes about, but at least before the election.
I think that gag order is going to have to go away at some point, or most of it. I was a little surprised that most of it didn't go away after the verdict. And obviously, Trump is now asking for it to go away. But they have sort of indicated in their papers that they will probably agree to tailor it down. And they're asking that it stay in effect until sentencing, at least.
Yeah, and I think they're going to want to keep some portion of it in place with respect to the jury, at least as to identifying
maybe
jurors.
The jury, yeah.
All right, Jeff asks, if Lawfare were to file an amicus brief before Judge Cannon, which Trump motion would it be about, and who would appear to argue it? Roger, as Lawfare's man in Fort Pierce most recently, what's your answer to this?
Well, I guess I would enter a limited amicus in the special counsel case because as a reporter, I don't like reading amicus briefs, many of them, and I don't like reading gnarly ones. And I have a suspicion that at least one and possibly two of the amicus briefs are not complying with the local rules on font size. And
so you would file an amicus brief to enforce
I'm not going to name
local
names, but one of those briefs they get 31 lines of information in to a page, whereas the other briefs are about 23. And I take deep exception to that and would happily file
Anna, what about you?
I know exactly what motion Lawfare would file, which would be we would move to intervene and then move to Judge Cannon to change the venue from Fort Pierce to Miami.
Yeah.
Because that would be way more fun for all the reporters. And I think that, obviously, Alan, you could get the New York Times in on this as well. And, I think that I'd be happy to argue it, but as a reporter, probably shouldn't. So Scott or Natalie, I think, would do a great job arguing that as a result of how hard it is to get to Fort Pierce and how much better the coffee is in Miami, Judge Cannon should definitely move to that courthouse to hear this proceeding.
What about you, Alan? Do you have, obviously, you're now speaking on behalf of the corporate entity, the New York Times, but do you have any legal positions you want to commit the Sulzbergers to?
The only one would be the one we discussed before the show, which would simply be a motion to compel a decision on a trial date in relation to familial vacations. That's what I would file.
Yeah. So we were talking about this before we went live. We're all in agreement that none of the courts here, with the exception of Justice Merchan, has shown adequate deference to our vacation schedules, and that, it's very hard to plan the rest of your year when you don't know when trials are going to happen. All right. Jeff also asks, I guess this one's for me, how does Ben feel about the term lawfare becoming a Republican epithet expressing contempt for the rule of law? So I'm going to actually answer this seriously, which is I love it. And the reason I love it is for two reasons that are completely independent of each other. At a practical level, it causes people to Google the word lawfare. And if you Google the word lawfare, you end up on our site. And so I actually think it's terrific. And I encourage all Republicans from the former president on down to, Lara Trump to use the word lawfare profligately and is in as confusing a fashion as possible, because it brings new readers to the site. Some small percentage of them stay. The other reason I love it, which is the serious reason, is that when Jack Goldsmith and Bobby Chesney and I named the site Lawfare way back in the Pleistocene era in 2010, we did it as a kind of joke. We thought, law and warfare, war about law about warfare. It's kind of cute. It also was then used frequently as an epithet to refer to generally to human rights advocacy over and litigation over laws of war stuff. I was unaware of that when we named the site Lawfare, and a lot of my friends were deeply offended by the name of the site. One prominent scholar refused to write for Lawfare for 10 years over it. And so I find it very amusing, the evolution of the use of the word, its migration from the international law world into the American legal world. And I use it the way I have always used it, which is as a kind of playful description of warfare over the law and law about warfare. But I do love that the former president now routinely uses the term. Michael asks, what do you think the odds are that Judge Cannon might be the October surprise by granting one or more of his motions to dismiss in an opinion that is just one long Tom Fitton-style screed against the special counsel's office, but not until it is too late to have an appeal heard before the election? Roger, Alan, do you have thoughts on this?
I think if that were to happen, it's clear to me that the motion at issue would be the selective vindictive prosecution motion, because that's the most political one. I mean, there is a world in which in, mid-September or even a little later, there is a 3-day hearing in Fort Pierce during which Trump's lawyers get to make all of these arguments claiming that the Biden administration ginned up this case with the specific purpose of destroying Donald Trump's electoral viability. And then Judge Cannon grants it, right before the election, and Trump gets to campaign with the, ratification of his central political talking point, by a federal judge. I'm not saying it's going to happen, but that is like a scenario that you can imagine happening.
I sort of disagree. I agree that we're going to have that hearing, which will be very helpful to the Trump campaign in terms of talking points. And we're going to have it pretty close to the election. And that's how she's scheduling it. I think she'll be wary to grant that because it will be so untenable. If the case stays around, if Trump loses the election, this will be another wipeout. And it might be the one that, when you combine it with the previous wipeout, could get her wiped out. I think the special counsel is a different thing, because you have all of these icons of this conservative movement that are in favor of it, and you have some votes on the Supreme Court. It's not the sort of thing that could get you reassigned. It gives you street cred in that community that she wants to impress. Mukasey and Calabresi and Meese. And so I could see that really happening. That might be the hill she'd be willing to go up on. So that one I do worry about.
All right. Will Appleton, the floor is yours.
Quick question. Given the delay by the appeal in the Georgia case, retrospectively, do you think it was a mistake for Fani Willis to not recuse herself from that prosecution?
So here's the thing, is that in Georgia, it's not, Fani Willis can't just recuse herself and then it goes to someone else with it on her prosecution team. It would either be the entire office and all the people who have worked on this case for years are gone, or, she continues to fight to keep the case. So, and if it's the case that she recused herself and her entire office, then it would go to the prosecuting attorney's counsel to appoint someone to then take over the case. And that is a process that could take months. In the case of Burt Jones, for example, who Fani Willis was disqualified from investigating in 2022 before these folks were indicted, it took over 18 months for the prosecuting attorney's counsel to appoint a replacement. This is a huge case. A lot of district attorneys and prosecutors who might otherwise be willing to take a case related to some of these people just don't have the capacity to do it. It's a politically complicated case, especially in Georgia. There are other district attorneys' offices, for example, that just have things that they have to worry about with their constituency, not something that is happening in a county over. So you would have some problems finding someone who'd be willing to take the case, especially because this is a case that Fani Willis herself has been so deeply personally involved in. I've always said the case lives or dies with Fani Willis, for better or worse. And that is exactly what we have here. So I think in retrospect, no, there was absent her resigning from her post, which she would never do because she has national political or higher office political ambitions. That would be the only situation in which this case would stay in Fulton County's hands and with that prosecution team's hands because of the rules in Georgia. So it is what it is. And the case isn't going forward until much later, 2025 at the very earliest that it could move forward. And that depends on whether Trump wins the election too. So we'll see.
John Hawkinson, the floor is yours.
Thanks, Ben. So I wanted to note that Matthew Seligman is one of the amici that Judge Cannon approved, and that he was the bar prosecution's star witness about election history in the John Eastman bar proceedings. So it's not totally pro-Trump folks who got amici time. But I also am wondering, to turn this into a question, is it a problem that he is now arguing in court, advocating basically for a side, when he's also an expert witness in some bar proceedings and presumably would be in others? I don't know. It seems a little weird to have those dual roles.
So I don't think so. So he is, first of all, this case is not connected to January 6th. It's the conduct is not overlapping. None of the people that he is testifying against in bar proceedings are defendants in this case. None of their conduct is at issue in this case. So I really see it. I'd be curious whether either Alan or Roger disagrees with me. It's really the link between them is that one defendant is Donald Trump on different conduct. And I don't see that as something that disqualifies either an expert witness or counsel.
I agree.
I think I agree. I didn't know about Seligman's other role, but I'll leave it there.
Well, I will say too that we've also had Matthew on the Lawfare podcast, in fact, because he represented amicus in the January 6th immunity issues before the DC Court of Appeals. But I am in agreement with you, Ben, that I don't think it's a conflict. But thank you, John, for pointing out that, because I'm not sure if it was not clear in our conversation earlier, but yes, there's two people who are arguing in support of the motion by Trump. And then Matthew is one of the counsel who has been allotted time to argue against the motion in support of Trump's motion, arguing that the special counsel's appointment was unconstitutional.
I mean, the fact that Seligman is being granted time doesn't mitigate the fact that it's kind of weird that she's granting time at all
to anybody
in this way, right?
Right.
I mean, that's just like objectively unusual.
I was trying to think of the only cases that I can think of in which amici are granted time at the district court level in arguments are situations in which they're court-appointed amici because somebody won't make an argument for a particular side. So the court kind of asks a lawyer to make that argument. That's relatively typical, although the situation doesn't come up that often, but it's not it's a very normal thing. But just having somebody submit an amicus brief and then ask for and get argument time is a very weird thing to happen at a district court.
Actually, I don't think anyone even asked. I think she
did it
first. She invited.
The amici asked.
I think she invited first, and then she said, and then. In fact, you asked at a previous one of these, Ben, if I had read. Steve Calabrese wrote a post in Volok that said something about Judge Cannon is a heroine, and the reason he was calling her a heroine was because she had invited argument from his lawyer in this matter.
That's what I consider heroic.
In fact, as he put it, he said, she asked if my lawyer would argue, and he agreed.
All right, Jacob, the floor is yours.
Sure. So I guess prior to the immunity decision coming down from SCOTUS, whenever that is, what are the chances we're going to see an op-ed in the Wall Street Journal from one Samuel Anthony Alito Jr. saying, see, I recuse when it's necessary, and when I don't recuse in the immunity case, it's because I didn't think it was necessary.
Which recusal are you talking about?
Well, he recused today in the bankruptcy case.
Oh,
In a unanimous decision that everyone agreed with, he recused himself, presumably because I think it's a relative of Judge Ho's.
He also holds individual stocks, which can trigger recusals. And I can't tell if your question is somewhat joking, but I think there will be. I think most justices most of the time are not interested in speaking when it is not necessary about ethics matters. And I think he has spoken about this one already and been contradicted on the facts that he's articulated. So I don't expect that he will voluntarily speak up on it again. All right. We got a few more questions. I would like to get through them all. Anonymous attendee asks, what happens to the personnel on Jack Smith's team given the delays? What are they tasked with given the pauses in the case? Thanks. So this is not an issue in the Florida case because there's actually a lot of briefing and since she's holding hearings on all of these motions, there's actually a lot of work to do in that case. And remember that the underlying work in the case, particularly on the SEPA side, is still not done. So there's actually a fair bit of work for the trial team to do there. The January 6th case, I would assume there is not a protracted vacation for the people, but they are, I suspect, like more of the work has shifted over the last few months to the appellate group, which is headed by Michael Dreeben, and less is being done by the trial team. I wouldn't be surprised if some of those people who are, mostly detailees from the Justice Department have other functions that in their home units. But Alan, do you know anything about do you have any factual answer to this question rather than my speculation?
I have pure speculation and an imaginary answer. I have nothing factual, but I do wonder, and this is an open question that I would love to solicit all of your responses to. Should there be a remand to Judge Chutkin for some sort of fact-finding mission on what is an official act, what is a private act, how do you sort that out? It is, at least in theory, possible that there could be a multi-day evidentiary hearing, in which, witnesses like, I don't know, Mike Pence and Bill Barr and Pat Cipollone all get called to, talk about the allegations in the indictment and which bucket they fall into. And so in that version of events, you could have something that would resemble a mini trial without a verdict. And in my imaginary scenario, Tom Windham and his team are busily preparing for that evidentiary hearing.
Right. Yeah, I think that's a very possible scenario, Alan. And we saw something like this play out in Fulton County with the Mark Meadows Supremacy Clause immunity evidentiary hearing, in which Mark Meadows testified. And it's very possible that we could have a kind of similar evidentiary hearing, although, as you said, with a lot of other, witnesses, people like Mike Pence. But I just wonder if that has the same, kind of communicative effect, especially when it's not televised. People are reading about it through the work of journalists like us, yes, and hopefully we are doing justice to what is happening in the courtroom, but it's very different from a situation like in Fulton County, where you're able to actually watch the witnesses and their demeanor, and then you don't have a jury that's rendering a verdict. And, I still think that it's a very different kind of it would serve a very different function in terms of its symbolism or communicative effect than a jury verdict would before the election in terms of people making, their decisions.
Sure. I mean, look, I think that if one of the big questions is always, what are the political effects of the legal outcomes, right? And so we can talk about the political effect of a verdict, but, for argument's sake, an evidentiary hearing like that would have one sort of public service aspect to it. It would air the evidence that the special counsel's office has collected before the election, and the public would, at least in theory, know a little bit more than they know now, right? Because presumably Jack Smith's office has collected stuff beyond what the January 6th committee did. They fought those privilege battles for a reason. And so we would actually probably learn something that might be valuable in the service of, making a decision in the election.
All right, we're going to try to get through a couple more questions before time. Andrew asks, presumably Trump v. U.S. will be announced in the next couple of weeks, though the facts in that case are, of course, different from the Fulton County case. Team Trump would have good arguments that there is a lot of conceptual overlap. How would a ruling in any way favorable to Trump complicate the Fulton County case vis-a-vis him as a defendant there? Would Boy Wonder have to reanalyze Trump's presidential immunity arguments in light of the new precedent? The short answer to that question is yes. If you imagine a ruling that gives some degree of immunity to official presidential acts, you would have a number of passages of that indictment that you would have to analyze for does it describe an official presidential act, however the Supreme Court defines that, and B, if to the extent that it does, to what degree is it entitled to whatever immunity standard the court lays out. And so the answer to that question is if Trump wins even a little bit of immunity, that presumably covers immunity from a state prosecution as well. Laura asks, politics aside, according to normal legal practice, what beyond the facts and verdict of the New York case is Judge Merchan supposed to be allowed to consider in his sentencing decisions? Are violations of gag orders, absence of contrition, or other Trump's antics in or out of bounds? Alan, Anna, either of you want to take this?
I mean, in short, yes. Yes. I mean, no. I mean, in short, those are not out of bounds. Those can be considered, right?
Very much in bounds.
Yeah, 1,000% in bounds. It's just a matter of sort of what weight they're given. But Anna?
Yes, I think you've answered it. I don't have anything to add.
All right. Josh asks, hypothetical, clearly counterfactual question. Supposing the Florida documents case was before a judge like Tanya Chutkan instead of Cannon. 1, would we have a verdict by now? 2, would that be more consequence than the New York State verdict? So look, you cannot say definitively there would be a verdict by now. You don't know whether a jury would convict. You don't know. But you can say that the trial process to trial would have been much more expeditious, and the likelihood that we would have a trial would be non-trivial. Would it be of more consequence than the New York State verdict? Absolutely, assuming you had a conviction. And the reason for that is that these are heart attack, serious level federal felonies that carry major jail time, and that the federal government is aggressive about getting significant jail time for in like cases, to the extent there are like cases. These are not the equivalent of New York State Class E felonies. And there would certainly be presumptively prison time under the sentencing guidelines for these offenses, and it would be substantial. All right. We are out of time. Thank you to Alan. Come back and join us anytime. We do this every week. We'd love to have you back. Roger from the Scott studio, Anna from the New York post-verdict pop-up room at her palatial mansion. Thanks for joining us, and thanks to all of you who are joining us in the Zoom and on YouTube. If you're joining us on YouTube and you want to have your questions answered in the future, come into the light. Join us in the inner sanctum. You can do that by becoming a material supporter of Lawfare at lawfaremedia.org/support. You are all great Americans, and we will see you next time.